The number you have reached, 911, has been changed to a non-published number.
Hi, I'm Ken Lammers, and this is Spot the Wonder Dog, and you've reached Cltv. And I'm going to let Spot go here because, you know, he's not the biggest fan of being a lapdog. This week, what we're going to go over is, well, the typical thing we do at the end of the week. I'm going to go through my 5 favorite posts of the week and lay them out for you and let y'all decide what you think about them and comment. First of all, Simple Justice. And Simple Justice has a post about a judge who is putting all those Reader's Digest, you know, word powers that he's read through the years to good use. And he particularly points out one section, and I'm going to read it here.
The sole attenuative circumstance urged by the dissent is that, after the frisk, defendant was not arrested and placed in handcuffs. It is not explained, however, how this forbearance from even more pronounced illegal intrusion would have communicated to defendant that, notwithstanding the just concluded frisk, he was no longer subject to the authority of the officers who had in the preceding moments blockaded the car in which he was a passenger, prevented him from exiting the vehicle, and then directed him out of the vehicle where he was summarily frisked. It will nearly always be possible to hypothesize some greater level of intrusion to which a defendant might be submitted. Attenuation, however, does not lie in an imagined differential, but in an appreciable diminution of the coercive sequelae of prior illegality.
Now, you know, I made it through most of that. There was only one word I had to look up, and it's probably the same word every one of y'all had to look up, I think. And I do agree with Simple Justice that it is kind of refreshing to read something like this once. However, I really, really, really don't want judges doing this in every single opinion, because I can't imagine trying to go through and parse 25 opinions on, say, robbery. If they were all written in this kind of language, it's just a nightmare. You know, I'm a big believer in the KISS principle, and like I said, I find this kind of refreshing. I hope it's not a trend. And by the way, Simple Justice, I do like your favicon or favicon or however you want to pronounce it. You probably want to use, or I'd suggest you probably use darker letters in it because it's kind of hard to see the white against the green. But that's just a suggestion for me. It does show up in Opera. I doubt you've checked against Opera. You probably use Firefox, but as in all of them, it doesn't show in Explorer, and I don't understand why. Well, moving on though. Next is life at the Harrison County Criminal Justice Center, and the criminal lawyer writing this, who won't admit to being male, female, or other, or you know, whether the criminal lawyer is a prosecutor, although clearly some people believe the person writing this is a prosecutor, or whether the criminal lawyer is a defense attorney who has been a prosecutor in the past, won't admit to any of it. Anyway, what life at Harrison County is talking about is a situation which is troubling to, I mean, pretty much anybody that's in a courtroom, and it is troubling to prosecutors. It's the type of situation you're talking about where somebody's come to court and they have serious mental problems, and the serious mental problems, you know, can make them a danger to themselves and others. But you know, whether or not they're technically insane by the law, you know, where they can't tell the difference between right and wrong, or they have to follow compulsion, they have some sort of serious mental issues. So what can you do with this? Because, you know, if you cut the guy loose, he goes back out and becomes a dangerous to society again. If you don't cut him loose, you throw him in jail for 10 years for something. You're throwing him in jail for something he probably doesn't deserve that kind of time for. So you've got protection of society here, and what's kind of right and wrong to do for this one individual here, and basically in the end, life in Harrison County pretty much goes, what can we do? Legislature, please fix this. And good luck with that, by the way. Legislatures, sometimes try, but seldom get it entirely right. Well, can't really mention life at the Harrison County Criminal Justice Court without mentioning its polar opposite, which would be defending people. And well, defending people is well, first of all, let me say something. Defending People has adopted a new color scheme. It is bright white. And while I'm in favor of white-ish color schemes, I'm going blind reading this one. Mark, please put a little bit of gray in, or blue, or something in, to save my poor big glass of bespectacled eyes. Let me say it that way. And now, having offered my 2 cents worth where they really shouldn't be offered, let me go on and talk about what Defending People is talking about. Now, Defending People is reacting to something from life in the Harrison County, at the Harrison County Criminal Courthouse, Justice Center, however you say it, and is talking about who people perceive as being the criminals, or the offenders, or defendants, however you want to state it. And he's talking about, look, generally it's not your axe murderer. It's somebody who's a little bit more sympathetic than that. The kind of person who's, works during the day and maybe stole a power saw from work or something like that, and that sort of thing. Or, who might not actually be guilty, who you're defending, or who, even if he's the axe murderer, might have some sort of, explanation for it, some sort of reason for what happened. You can't really explain an axe murder away, but some sort of familial historical, or societal historical reason that could be mitigation. And he goes on and he starts talking about, what the proper functions of punishment are. And I've actually been working on a post about this, which eventually will hit the front page of my blog. But and he lists through several, and the other one he seriously dismisses is retribution. And while I'm not the biggest fan of retribution, I don't think it's something that can be dismissed, because, well, as long as we have chosen, and we have chosen, I don't know of any state that does not have its prosecutors elected, the citizenry expects retribution. And as long as there is an elected official in that office, that is a portion of what they're elected to do. It may not be what we approve of in a theoretical manner or something like that, but it's there, and it's something you have to take into account. How much you take it into account, that can vary depending on the situation and everything, but it's something that has to be thought about. Now, the next we're going to come to is of counsel, and of counsel is talking about how Georgia's public defender system, which they put in place apparently trying to save money, is heading the opposite direction, and how the legislature has, well, started investigating the public defender system because of that. And of counsel puts up a post wherein she talks about, wherein she actually quotes the senator leading the investigation, and the senator leading the investigation has said something to the effect of, it's gone from 60 or 70 million to 110 million, and people seem to think that because they're indigent, they're entitled to a full defense, and they should get, you know, all this stuff paid for by the state government, and you know, that's why everybody's. Is it any wonder that 90% of criminal defendants are indigent? Then something along those lines. Go read it actually on the blog post. I don't necessarily. I mean, well, I don't necessarily. I don't really agree with the whole. Well, they're becoming indigent defendants because they think that then they'll have an unlimited amount of money that'll be spent for their defense. Don't really agree with that. On the other hand, I do have to say that, you know, whenever you have a jump from 60 or 70 million to 110 million, that's a pretty huge leap. And I am curious if that's, I don't know if that's per county average or if that's a, you know, whole state average. Whole state seems a little bit low, but, you know, it might be the whole state. In any way, if you've got a, you know, a $40 million jump, well, that's something that, you know, the legislature should probably be looking into, trying to figure it out. You know, is it some sort of unnecessary bureaucracy that's been put in place or something along those lines? I don't know. But I can see why the legislature would look into it. And I would actually kind of be surprised and maybe a little bit upset if, you know, the General Assembly in Virginia, facing some sort of huge jump like that, didn't investigate it. And finally today we have Objection. An objection is posting about a trial. A very quick, brief part of the posting is about the jury trial in which the defendant is found guilty, and you know, Objection stands up and recommends a, you know, a pretty lenient sentence. And defense counsel gets up and mentions a pretty lenient sentence, which I'm sure is asked for even more lenient than the prosecutor did, Objection did. And then, lo and behold, the defendant gets up and, you know, unbelieving of the fact that how could they convict me? I didn't do this thing, this sort of thing we've all heard before. Basically does his best, his level best, to not get the fine that everybody's recommended and actually end himself up with 90 days of jail. Eventually it all works out, but it's one of those defendants that doesn't take the hint that, you know, he should just shut up and, you know, take his lumps and maybe appeal later. He does his best to try to make the situation worse. And ladies and gentlemen, that's it for today. I thank you all for watching, and I'll be back next week. Got a jury trial on Friday, so I don't know if I'll get something worked up for Monday. I'll try to, but I'll definitely be back at the end of next week and get you all a favorite 5 post again, and I look forward to it. Y'all have a good week now.